Welcome to International Trade Minute Quickfire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we are exploring the latest on CBP's ruling about green food ingredients transactions, insights into OFAC's redesignation process and its implications for global businesses, the new U.S. export control training requirements for universities and research institutions, and the recent lawsuit by environmental groups challenging the lack of import bans on international fisheries. We will delve into the key details of these pressing stories. Let's get started. In a recent ruling, U.S. Customs and Border Protection determined that transactions between green food ingredients and Jingxiang Lunong agricultural trading do not qualify as a bona fide first sale for appraisement. This decision has significant implications for import valuations, especially in the agricultural sector. CBP found insufficient evidence to establish a genuine buyer-seller relationship between green food and Jingxiang, despite claims of their independence. Additionally, a separate audit revealed that Green Food's entries were undervalued, leading to a substantial underpayment of $589,623 in duties and fees between September 2017 and February 2019, highlighting CBP's emphasis on accurate appraisement. CBP reviewed documentation, including invoices and bills of lading, and found inconsistencies like the use of an erroneous original CIF term and unclear post-entry invoices. These issues suggested that transactions between Green Food, Jingxiang, and McCormick were not independent, but part of a continuous value chain, with Green Food acting more as a middleman. CBP also noted that Green Food and Jingxiang admitted to being related parties, which undermined claims of an independent buyer-seller relationship. The lack of proper documentation, such as purchase orders and proof of payment, led CBP to conclude that the true sale for customs purposes was between Jingxiang and the end U.S. customer, McCormick. One of the most telling points was that the invoices from both sets of supposed sales, between Jingxiang to Green Food and Green Food to McCormick, shared identical formats and dates, issued on July 23, 2018. This alignment suggested a lack of separation between the transactions and indicated a direct transfer from Jingxiang to McCormick, bypassing Green Food as an independent party. For practitioners, the takeaway highlights the importance of documenting every facet of transactions thoroughly when asserting a first sale for appraisement. This includes clear and distinct evidence of buyer-seller transactions, titles, risk of loss transfers, and accurate invoicing that reflects true sales terms. In conclusion, this ruling emphasizes that related party transactions need meticulous documentation to prove bona fide sales. The ramifications of failing to do so are clear in the form of CBP's stringent evaluations and the financial consequences of undervaluation. For those involved in similar import operations, it's crucial to re-examine your documentation processes and ensure full compliance to avoid similar pitfalls. Moving on to our next story, the recent OFAC redesignation of Paraguayan tobacco company Tabisa under the Global Magnitsky Sanctions Program offers an illuminating case study for global businesses. Despite a change in ownership, Tabisa was redesignated due to its continued financial ties with its former owner, Horacio Manuel Cartes Jara, sanctioned for corruption in 2023. This move by OFAC underscores a critical lesson in the realm of sanctions compliance. Simply changing ownership isn't enough to avoid the watchful eyes of regulators. OFAC's actions spotlight the need for companies to maintain a vigilant and proactive approach to compliance. What does this mean for trade practitioners? Key steps for compliance must be meticulously documented, rigorously executed, and promptly updated. First and foremost, comprehensive documentation is crucial. Businesses must maintain detailed records of any ownership changes and ensure that every financial transaction, especially those involving previously associated sanctioned individuals, is thoroughly documented. Corporate governance documents should clearly reflect the separation from sanctioned entities or individuals. This detailed paper trail will serve as vital evidence to underscore your organization's commitment to compliance. Next, rigorous due diligence is imperative. Thorough background checks on new owners and key stakeholders must be conducted without exceptions. Enhanced screening procedures for ongoing business relationships can further fortify a company's compliance status. Every new association should be scrutinized through the lens of potential indirect financial benefits to sanctioned parties to avoid unforeseen pitfalls. In parallel, a compliance program overhaul might be necessary. Review and update your sanctions compliance program to ensure it remains robust and comprehensive. Implementing robust internal controls to prevent any inadvertent support to sanctioned parties is essential. Compliance isn't a one-time effort, but a continuous process requiring regular audits and updates based on evolving regulations. Engagement with OFAC is another critical element. If your company finds itself in a situation similar to Tabisa's, a detailed petition for removal from the SDN list should be prepared. This petition must include clear evidence of changes in ownership, control, and financial relationships, demonstrating an unwavering commitment to compliance with concrete policies and procedures. In the case of financial audit, a third-party audit of financial transactions might be warranted to ensure transparency and accuracy. Be prepared to disclose any lingering financial ties to sanctioned individuals or entities fully. This not only reinforces the credibility of your compliance efforts, but also ensures that potential issues are identified and addressed promptly. Looking ahead, future planning should include strategies to wind down any remaining connections to sanctioned parties. Crafting a roadmap for full compliance and a seismic shift away from sanctioned entities can safeguard against future discrepancies. Proactive measures today can prevent the complexities of redesignation tomorrow. For global businesses, the Tabisa case serves as a stark reminder that OFAC sanctions compliance extends well beyond mere ownership considerations. Businesses must be prepared for ongoing scrutiny and the possibility of redesignation, even after apparent compliance measures have been executed. As OFAC continues to refine its approach, staying ahead of compliance requirements is more critical than ever. Being proactive and thorough in your compliance strategy can make the difference between seamless operations and unexpected sanctions. Stay tuned, stay compliant, and navigate this complex landscape with diligence and foresight. Next up on queue, new guidelines issued by the White House's Office of Science Technology Policy are set to raise the stakes for export compliance at universities and research institutions, particularly those benefiting from federal semiconductor-related funding under the CHIPS Act. These changes demand that schools and research organizations receiving federal research funds certify their implementation of export control training, research security protocols, and robust cybersecurity measures. Universities and research entities are now required to certify the completion of Bureau of Industry and Security-administered training or provide proof of alternative relevant training on export control regulations and procedures for evaluating foreign sponsorships and partnerships. This certification needs to be submitted to the Federal Research Agency in the form of a written or electronic attestation. Law firms like Hogan Lovells have noted that although many institutions have proactively addressed research security over recent years, the new guidelines add more layers to the already complex compliance landscape. The flexibility allotted to institutions for developing these security programs means that while they have room for customization, there's also a significant need to track and satisfy these new and upcoming requirements thoroughly. Ropes and Gray highlighted that despite some institutions already planning for these new expectations, there's still a substantial amount of work to ensure readiness for the additional agency-specific requirements. This is especially true given that institutions also need to implement training on foreign travel security. This training ensures that researchers do not inadvertently disclose sensitive information during professional travel outside the country. Holland and Knight pointed out that compliance with the new policy might not be mandatory until federal agencies themselves have updated their internal policies to align with these guidelines. This grants universities and other research organizations some leeway to evaluate their existing research security programs, pinpoint deficiencies, and ensure compliance well before any official requirements take effect. The final guidance issued also clarifies that training and reporting obligations regarding international travel should relate directly to institutional activities like conferences, teaching, and research travel rather than personal travel. This stipulation provides a clearer framework for universities to tailor their training programs specifically for professional activities, simplifying some aspects of their prep work. Given the extended timeline before mandatory action, it's crucial for institutions to thoroughly assess their current security programs and initiate enhancements wherever gaps are identified. Preparing ahead will not only ensure smooth transitions, but will also position these entities to comply without unnecessary rush or oversight, thus safeguarding their eligibility for crucial federal research funding. With the increased requirement for specific export control measures, institutions are urged to remain vigilant and proactive, continually updating their training programs and security protocols to meet both current and forthcoming regulations. Preparing now is not just about compliance, but also about ensuring continued support and funding for valuable research initiatives. In our concluding segment, 3 wildlife advocacy groups are taking legal action against several federal agencies for failing to enforce import bans on fish products from international fisheries that don't meet U.S. bycatch standards under the Marine Mammal Protection Act, MMPA. The Natural Resources Defense Council, the Center for Biological Diversity, and the Animal Welfare Institute filed their complaint at the Court of International Trade on August 8th. They allege that fisheries in 9 nations, Canada, Ecuador, France, India, Indonesia, Mexico, South Africa, the UK, and South Korea, haven't adhered to U.S. bycatch regulations, yet the Commerce, Treasury, and Homeland Security departments, along with the National Marine Fisheries Service, NMFS, have not prohibited the import of fish from these non-compliant fisheries. The advocacy groups accuse the NMFS of not performing its duty under the MMPA, which mandates import bans on fish and fish products from foreign nations whose fishing practices endanger marine mammals. The lawsuit also claims that the NMFS violated the Administrative Procedure Act by not providing a notice and comment period when extending the compliance deadline multiple times. Initially, the NMFS granted a one-time 5-year extension to exporting nations in 2016, but has since issued 3 additional extensions, with the latest lasting until January 2026 and without any public input. Central to the suit is the assertion that the use of indiscriminate fishing methods, such as gill nets by these nations, has significant detrimental effects on marine mammal populations. For instance, the fisheries in question failed to provide essential reports to the Commerce Secretary regarding their compliance with U.S. standards, an omission which the groups argue should trigger an immediate import ban as stipulated by the MMPA. The advocacy groups assert that their members are directly affected by the lack of enforcement since they live in or travel to areas where they enjoy marine mammal observation. The Natural Resources Defense Council in particular contends that its members' recreational, aesthetic, and conservation interests are being harmed by the continued importation of fish from these non-compliant fisheries. The legal move, anchored in Section 1581I, under the court's residual jurisdiction, seeks to compel the federal agencies to fulfill their statutory responsibilities. The MMPA's intent is clear. If a foreign nation doesn't meet benchmark standards for bycatch reduction, the U.S. must restrict imports from those nations to protect marine mammal populations. As this lawsuit progresses, trade practitioners should stay vigilant, particularly those involved with seafood importation. Ensuring full compliance with both U.S. and international regulations will remain crucial to navigating these increasingly scrutinized waters, where environmental oversight and import compliance intersect. The outcome of this case may also set a precedent, potentially influencing future regulatory actions and compliance strategies across the industry. Thanks for tuning in to International Trade Minute, Quick-Fire Trade News. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.